My parents were victimized yet a second time by the DA's office by repeatedly being demeaned, belittled, ridiculed, and dismissed by the deputy district attorney whose actions were defended and condoned.
Donnie Harmo broke into a sleeping couple's home with bear spray, a pry bar, and a loaded accomplice hiding in the bushes. But before a single day of justice could be delivered, DA Ann Kelly's office made sure Bill and Peggy Metz suffered a second time, quietly, systematically, and from behind a government desk. Bill Metz is 81 years old. He still works full time on his family's potato and grain farming operation. He has lived in the same house since 1987, nearly 40 years in one place. A man who built something, stayed somewhere, and asked nothing from anyone except to be left alone.
Bill Metz, Kenneth William Metz. I just have some comments that I would like to make. It's bothered me over the last 9 months. Very frustrated. First part, I can't figure out why we were targeted, or I was targeted with pepper spray. I've lived in that same house since 87, so that's coming up to.
His wife, Peggy, is in her 80s. She sleeps with an oxygen machine. She has moderate dementia. Her world was already fragile before that July night. Before Donnie Harmo crouched outside their bedroom window in the dark. It was a warm night. The window was open. They were asleep. Harmo sprayed bear spray directly through that open bedroom window. It saturated Bill's head. It soaked his face. His clothes were drenched. The chemical cloud filled the room where Peggy's oxygen machine was running. Her nose, eyes, lungs, and throat burned for days. Bill had just had a surgical procedure on the side of his face. The bear spray hit that wound directly.
Prior to this incident, there were also physical injuries. Donnie, the bear spray that you sprayed through my parents' bedroom window saturated my dad's head and face. And as if that wasn't terrible enough, he had just had a surgical procedure done on the side of his face, and you caused him excruciating pain and agony.
His daughter Tanya would later describe the pain he experienced as excruciating. That is not a dramatic word. That is the only accurate one. They could not stay in their home for days. The bear spray had destroyed furniture, bedding, carpet, walls, ceiling. Belongings that took a lifetime to accumulate, ruined overnight. And that was only what Harmo managed to do before he was caught hiding in the bushes outside. When the fire department arrived, the chief walked one step through the front door, turned around, and said, "You have a chemical spray." His crew searched the property, found Donnie Harmo crouching in the bushes with a backpack. Inside that backpack was bear spray, a pry bar, a hammer, and a screwdriver. Everything needed to break in, subdue, and rob an elderly couple in their beds. Deputies found a second man hiding in
up to 40 years. I think my frustration has been with the DA office. The only time that I ever had any communication with them was probably a month after the incident happened in July, at which time I met with them, explained what happened. They told me at that time that they didn't know how they were going to handle this case because it was of the bear spray.
Bill called them. He emailed. He called again. He wanted a face meeting to understand what was happening with his own case. The response he received from the DA's office was simple. "We are too busy to talk. We can do a phone conference."
To find out what was going on. The only response I got back from them was, "We're too busy to talk. We can do a phone conference." Well, in my opinion, if you can do a phone conference with me, you can do a face-to-face call with me. It won't take any more time, but they wouldn't have anything to do that.
Months passed. Bill confronted a DA representative in person, frustrated enough that he got in her face about it. He was reprimanded for that. He apologized. He explained himself. He said there was no communication, no updates, no information reaching him at all. The DA's office responded by promising to send him a monthly email. He is still waiting on the first one.
Let me know what's going on. She and Miller said, well, we can correct that a little bit. We will send you a monthly email letting you know what's happening. I'm still waiting on the first email.
Months passed. Bill confronted a DA representative in person, frustrated enough that he got in her face about it. He was reprimanded for that. He apologized. He explained himself. He said there was no communication, no updates, no information reaching him at all. The DA's office responded by promising to send him a monthly email. He is still waiting on the first one.
A court hearing here in February. We showed up. 11:30 comes. Nobody here except the defense. So I went up and asked the clerk. I says, what's going on? Where's the DA? She didn't call you to tell you about there's no meeting? I said, oh no, she didn't call me. So that frustrated me.
The fire chief, who was first on the scene, the man who identified the chemical spray and whose crew physically found Harmo in the bushes, was never contacted by the DA's office. Not once, no interview, no follow-up. The investigators from the Rio Grande Sheriff's Office who filed a detailed and complete report that same night were never consulted further. Leads that were provided to the DA's office went nowhere.
No, nobody's ever contacted him. Yeah, I got a bunch of stuff here, but basically, that's my frustration. I wasn't represented. I never knew of any of the plea bargain. What was going on? They did it on their own without consulting me.
And then came the plea deal. Not a conversation about a plea deal, not a proposal, not a question, a decision. The DA's office negotiated a plea agreement with Donnie Harmo offering 90 days in county jail and probation. They did not ask Bill and Peggy what they thought. They did not call to discuss it. They presented it as final. When the family expressed extreme dissatisfaction, they were told it could not be changed.
For how they have and continue to suffer. While I understand the plea agreement offered today to Donnie Jaramillo is 90 days in county jail, I would ask you, Judge, please consider the magnitude of anguish, fear, frustration, and hell my parents are still enduring daily, and what they still have to remember and suffer with in each future day as a result of the crime they are the victim.
90 days. For a pre-planned attack on two elderly people sleeping in their home, for bear spray on a surgical wound, for chemical burns in the lungs of a woman on oxygen.
My mother sleeps with oxygen, and the bear spray caused her to suffer from nose, eye, lung, and throat irritation for many days following your choice to do this. They were unable to stay in their home for several days.
Not for a loaded gun in the bushes. For nearly a year of Peggy Metz being unable to leave her own house without paranoia. For a security system now installed where there never was one. For a loaded weapon Bill now keeps within reach because he never had to before. Tanya Metz stood before the judge and said 90 days in county jail is not a drop in the bucket compared to the 11 months and still counting of hell her parents have been forced to
Department
live.
of Corrections. I feel 90 days in county jail is not acceptable, nor is it even a drop in the bucket compared to the 11 months and still counting of hell my parents have been forced to live. Your Honor, Donnie Jaramillo has proven himself to be a repeat offender. I am asking you to make an example and send a message by sending him for his actions to the full 18 months in the Department of Corrections.
18 months in the Department of Corrections. No bond, no credit for time served. She said Donnie Harmo is a repeat offender and the court should make an example. She said her faith in the judicial process was hanging on what happened next. The judge cut right
And
to it.
Kelly.
I'm not inclined to accept the plea. I'm not going to be bound by an offer that was not properly vetted through the Victims' Rights Act. Is the district attorney prepared to proceed, Mr. Martinez?
Yes, Your Honor, we are.
He looked at the DA's office and asked a simple question.
All right, well, let me cut right to the chase. I mean, I got a victim telling me that they weren't consulted regarding the plea. In this case, you've made a plea agreement, or the DA's office has made a plea agreement in this case to stipulating to probation with a jail sentence. Why should I accept that if the victim was not consulted in this manner?
Why should I accept this plea if the victim was not consulted? The prosecutor acknowledged that in their office's practice, plea offers were sometimes extended without victim consultation, and that appeared to be what happened here.
From my understanding, our office told him what the plea was. What they were upset about was that they weren't consulted and their opinion wasn't heard. So it technically would be compliant with the VRA,
But not the spirit of the law.
spirit.
I'm not inclined to accept the plea. I will allow the defendant to withdraw his plea if he so chooses to, but
The defense attorney asked the court to move forward anyway, given the trial deadline that had been approaching. The judge was not interested in the timeline as a justification. He stated clearly that a victim standing before him had said she was not consulted, that she was simply told what was going to happen, and that, in his view, that was not compliance with the Victims' Rights Act. Not technical compliance, not the spirit of it, not any version of it that he was prepared to accept. Then DA Ann Kelly herself appeared on the record. She said her office had spent hours upon hours with this family. She said she had personally given more time to these victims than she typically gives to most victims in the Valley. She said she strongly disagreed with the court's finding. She said she took personal offense to the suggestion that her office had failed to consult the victims. She provided no documentation, no call logs, no emails, no dates, no
With
names.
the finding, we have not violated the Victims' Rights Act. In fact, we have spent hours upon hours consulting with, hearing from, listening to, and being present for the victims in this case. Hours with me personally, Judge. It is not correct that we have not complied with the Victims' Rights Act. We have gone above and beyond to make sure that this.
No evidence of any kind. Just the claim, delivered with visible frustration that her office had gone above and beyond. Her connection dropped mid-statement. The court noted the record was clear that she had not been cut off. When she reconnected, she continued with the same position. Hours of consultation, personal involvement, complete compliance, and finished by challenging the victim's family to name specifically what meeting had not been scheduled, what time had not been given, what concern had not been taken seriously. Bill Metz had already answered that question. He answered it under oath, with dates, with specific interactions, with the name of the email that never came in the court hearing where no one from the DA
with your client about that, I'll give you that opportunity. But my finding at this point is that the district attorney did not properly comply with the Victims' Rights Act in making this offer, and as such, I cannot accept it.